Good evening. This is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're into week 6 of term 2, 2019. And this week we make the transition from the work that centres around negotiation, mediation and conciliation and move towards arbitration. As a result of that, this will be the last week that we formally deal with issues to do with the first assessment. But next week, if you have any questions, happy to raise that and discuss the assessment piece. I trust that by now, most of you have organised the work that you intend to present for the first assessment, that you're working with your groups and that you're effectively ready to go. I sent a reminder out to everyone today to say it's due, I think, on the 12th of September. Please correct me if I'm wrong. And I expect that you will have your work submitted by that time. So allowing for the possibility of becoming busy, becoming unwell, others around you becoming busy or unwell, or otherwise unforeseen circumstances, best if you at least have something to prepare well before that. So this is why I'm saying tonight is the last night that I'll formally provide any further information. All right, well, let's start in terms of the assessment about things like breaking deadlocks and some of the strategies that you might adopt if you find yourself needing to break deadlocks. Now, of course, almost in every mediation or conciliation, there will be deadlocks at some stage or other. I'll go through a few points. I'll invite your comment. I'll invite your further discussion points as well. But a few things come to my mind in terms of your ability to break deadlocks. The first is that you must have done some good groundwork. In other words, before you can break deadlocks, the parties need to feel that they've built a rapport with you. They feel trust in your work and they feel that they can trust you. In short, to adopt something from Professor Ashman at QCAT, have you become the party's new best friend? Now that is both of them equally. In other words, have you made a real connection and have you demonstrated understanding? If you have, you're going a long way to being in a position to assist the parties to break the deadlock. In terms of the overall structure, a few things that I'll be looking for in that regard that you need to be mindful of for your assessment are these. Have I created a safe environment? Or in your context, so it's a question that you need to ask yourself. You need to ask yourself, have I assisted the parties to communicate in a meaningful way? Have I encouraged settlement? Sometimes people want you to ask and they want you to acknowledge the issues that they've got. So have you encouraged settlement? To do that, you probably need to remove some blockages. And one of the early ones, of course, is where you need to encourage the parties to vent to some degree, if necessary, and sponge to absorb that venting. So have you removed blockages generally? In order to come to a resolution, we need to have some common ground. And the first common ground is the agenda. So I'll be looking to see that you've set some sort of agenda items for discussion. I know you've only got 25 minutes, so you don't want a complex set of agenda items. And usually in a mediation that lasts for 3 hours, I try to restrict it to 3 to 5 agenda items anyway. In the course of setting the agenda, you're looking to tease out the underlying issues and, of course, move the parties from their positions to a real genuine discussion about the issues underlying. In order to do that, you need to have shown me that you've got the ability to listen actively, to really get to understand the issues that are of concern to the clients. Now, to do that, you need to be light on your feet. Again, to borrow something that I heard through QCAT, this time from President Kingham, Judge Kingham, as Her Honour was at that time. So are you light on your feet? By that I mean, are you listening actively? Are you listening for the cues? Are you able to move to work with the parties rather than necessarily against them or to direct them? These are some of the skills that I'd be looking for in your work. Of course, you need to be fair between the parties, and usually that's a function of spending at least equal time. But you'll understand that particularly at the start, I'll be looking to see if you have taken the time, the trouble, and demonstrated the expertise to move from one party to the other equally. You'd be surprised how often I see mediators or conciliators who seem to direct most of their attention and comments to one party to the exclusion of the other. So I'll be watching for that. So you may need to take some practice runs. As you're practicing your opening statement, perhaps do so in front of some family or friends or even a mirror and gauge the attitude as to whether they felt that you were treating them fairly. You may need to consider a shuttle mediation, but I would recommend against it for the assessment purposes. But if you find that the parties are at a stage where they're threatening to walk out and you might otherwise consider a shuttle, think about some techniques to keep them in the room, as it were. I don't mind if you have private sessions, but what I'd be concerned about is if you have, for want of a better term, a full-on shuttle mediation. So there might be some techniques that you use to keep the parties engaged in the process and avoid a walkout. One of the good ways to do it is maybe to ask for a short break, see if the parties need some independent advice, things of that nature. You may need to show some ability to assist the parties in creating some alternatives for consideration. So this is where you can demonstrate your creativity. And this goes to the heart of the difference between ADR and something which is decided by the courts. In other words, as an example, you might say, well, rather than having to come to an agreement today, a dollar figure, let's talk about a formula that works for you. So it might be, for example, that you have a formula where the parties choose, even during the mediation session, 2 experts. They agree on a brief for the experts, and they agree that the average figure that arrived at by the 2 experts will be the final figure that they come to as a resolution. So very often when we're talking about money disputes, a bit like purchasing real estate, you might get one party stuck at $300,000, the other one stuck at $400,000. They're not going to budge, they're not moving. Then you need to be creative and say, let's work out some sort of formula that will lead to a result, even though we can't come to a final result ourselves today. In order to do the task well, as a mediator or conciliator, I will be looking for your ability to remain composed, to remain confident, to remain capable, and to be supportive of the parties. And to do that, you might need to ask the participants some relevant questions. So, have you thought through the matters entirely? Have you thought through the consequences? So that might be one stock question. And you might come up with a few so that you can rely on some go-to questions, particularly if you get stuck. You might ask this sort of question. Are you sure you have all the relevant information and knowledge available to you now to make a fully informed decision to litigate? So if the parties are saying, well, we're getting nowhere, we're going to litigation, just have something that will stop them to reflect. So are you confident you have all the information, you have all the knowledge so that you can make a fully informed decision that litigation is the best way, or should we keep talking? Another is, have you consulted experts? If so, what are the experts telling you to consider? you might consider doing that in a private session. That might be a matter for you to determine. If you have not engaged experts, then you might ask the participants as to whether there is a risk that they're proceeding to litigate without knowing the full risk and without knowing the full cost consequences. So there are some basic questions, but there's a few more. A good sort of stock question, have up your sleeve, is, have you considered this from the perspective of the other party? You might do that in open session, in which case it would be a question asked of both of them, or it might be probably more typically in a private session. Another good one to get the parties to stop and think before they decide to get up and walk away is this question. Have you considered this dispute in terms of the cost, both in financial and emotional terms? Have you considered, for example, the cost to you in your relationships in continuing? And do you have the time to pursue this matter? Because to litigate, even if you engage lawyers, is still going to call upon you to provide a considerable expenditure of your time. Now, can you afford that? Are you losing out on opportunities that you might otherwise have if you were to settle this today? Even though you're not entirely happy with what we're considering, at least you'll be able to generate some positive income or time as a result of settling the matter. So fairly bluntly, you might say as a stock question, do you have better things to do with your time than dealing with this litigation? What would you do with your time and your money if the litigation was behind you? How would you feel tomorrow morning if you woke up and the matter was finalised? What's your immediate thought? Do you expect that you would be hugely relieved and happy to know that the matter is behind you? Here's another one that I've used quite a bit and I find helpful. And that is asking this sort of question. Is there a danger that when this matter is ultimately resolved, if you don't settle it today, you will look back on today's events and ask yourself, why didn't it settle when I had the chance to do so on that day? So is there a danger that that might happen? Another question is, and it might seem an odd one, but it's actually relevant to some people, and that is, do you actually enjoy the process of litigation? Most people don't. Most people hate it, but some people really do like it. And if the answer comes back yes, then you might be wondering why the party is proceeding to mediation. Lonely people, maybe. And Tim says, part of the assessment is to persuade the disputing parties to steer well away from formal litigation. Let's sort it out at the mediation table. Yes, I think that's entirely right. So you can't force them, of course, but you're looking to gently persuade them. I think that's a good way of putting it, Tim. And Michael says that sometimes lonely people do actually enjoy litigation. And I think there's a little bit to that. So if so, if someone actually says, I do like litigation, what would you say to that? What would be your approach? Now, in my view, you're entitled, Gary says, consider it from the other party's perspective. In my view, you are entitled to challenge the motives and the motivation by a party. You probably do this in private session. If somebody says, I just enjoy litigation, then you might ask the question, are you taking your enjoyment at the expense of another party? And can you really live with that? Another very good stock question is, are you pursuing the litigation merely because of the principle of the thing? And why are you doing that when you have an opportunity to resolve the matter in a commercial, sensible way? Is fighting for the principle really going to solve anything? Gary says, what if the position involves children? Well, that's very good because people get very emotionally attached, of course. So I think the key there, the thing to always come back to is this, that every decision that's made in relation to the children must be in the child's best interest. So a stock question that you might ask participants is, in relation to any statements that are made, can you tell me that you make that statement, you provide that assertion, you offer that settlement opportunity in the child's best interest? If they can't say, well, this is in the child's best interest, then you have an opportunity to say, well, in that case, the court's not going to be interested in it. It's not relevant to the litigation. So let's not make it relevant now.
John?
Yes. Yes, Jack.
Is it perhaps worthwhile to gently remind them of the sort of vexation of what sort of happens to vexatious litigants?
That's a good point.
With the Vexatious Proceedings Act?
Yes.
For Queensland specifically.
Queensland, yes. No, that's a good point. I've never actually had someone that has been so stubborn that I've had to resort to that, but that's a good point. In extreme circumstances, yes, you might raise that issue with them. Thank you. So what other sort of standard questions might we come up with to use out of our toolkit at appropriate circumstances? Another one might be to challenge parties by saying, well, look, have you considered contingencies? Have you considered that your health or your current financial situation may not be the same at the end of the lengthy litigation as it is now? Have you considered potential unforeseen circumstances that might change your position? Do we need to take out, for want of a better term, some insurance by resolving the matter now rather than taking the risk, particularly given that things may change? Another question might be, have you considered the worst alternative to a negotiated agreement, which is the WATNA? Have you considered the best alternative to a negotiated agreement, which is the BATNA? When we were going through the slides, I think I showed you some checklists that you might use, and you can invite the parties to see if they've created some checklists and thought the process through. You can come up with a list of problem-solving questions for the parties to consider. What are the impediments to resolving the matter today? Why haven't we resolved the matter today? Things of that nature. You can certainly do some good work in private sessions. Sometimes parties don't wish to lose faith. And it might be, for example, that the reason it hasn't settled is that the party who's in the wrong and knows that they're in the wrong just doesn't have the money to pay. So they're fighting for some other reason. Ultimately, what you need to do is invite the parties to undertake some sort of cost-benefit analysis. So you can ask that question directly. Have you considered a cost-benefit analysis of proceeding to litigation as opposed to settling the matter today? You know, all of these questions effectively are designed to challenge the thinking and the expectations, and to some degree raise the reality of situations for parties that don't necessarily want to know about those things. It just seems to be human nature, doesn't it, that we avoid those things that are difficult and we avoid thinking about the consequences unless we really have to sometimes. So, general questions. Why haven't you been able to settle this matter yourselves? What would help to settle the conflict today? Ask yourself, are you truly being flexible and open? Understand that it's normal to feel frustrated and annoyed, but is it in your best interest to continue to feel that way when you could cut your losses, resolve the matter, and walk away, as it were? So they're just some of my thoughts in terms of what you need to build into your toolkit, some of the stock standard questions and concepts that you might like to raise with clients during the session. And of course, the aim of this unit is not just to get through the unit, but to actually assist you in becoming ADR practitioners, or at least being involved in assisting people that are going through the ADR process. So build checklists that work for you and that you can use in practice down the track. So are there any questions about what we've discussed in terms of mediation, conciliation, negotiation, and the first assessment? Because if there's not, we'll move on. Any questions? All good. All right. Okay. Week 6 deals with the issue of arbitration. And you'll recall on the list of continuum, if you like, of 14 types of ADR process, referred to on page 3 in figure 1.1 of your text, that arbitration is way down the bottom left, number 14. It is, of course, the most court-like of the ADR processes. It comes to a conclusion where an arbitrator makes a decision in the same sort of way that a court would make a decision. But can anyone tell me what the final decision of an arbitrator is called? Sorry, I almost gave the word away.
An award.
An award, thank you, Peter. It's an award, so it's not a decision as such. It is a decision. It's not an order as such, but it's an award. So contrast that to an order of the court or an agreement in mediation. So it's the most formal, the most legalistic of all the processes that we will explore. And it's definitely something that you need to be well aware of and study for the purposes of the final examination. So arbitrators can adopt different processes, and very often the process to be adopted by the parties is dictated to by the arbitrator in the same sort of way that a court or a magistrate, tribunal member may give directions as to the conduct of a matter. Likewise, arbitrators can do that. Now they may, now Gary raises an interesting point. Can a magistrate reject the agreement? So just on, if you're talking in the context of arbitration, just bear in mind that usually arbitration awards are not ratified, certainly not ratified by magistrates, if that's what you're getting at, Gary. All right, so in a way, the arbitration is a standalone process away from the courts in many instances. It's not to say that courts can't get involved, and they do get involved on a regular basis, and we'll talk about a number of cases in that regard. So arbitrators can adopt what we call an inquisitorial process, or they can adopt an adversarial process. We all know the difference between the two, don't we? I don't need to explain that. All good? All right. Arbitration can proceed with or without pleadings. Do we know what I mean? Do you know what I mean by pleadings? Who's done civil procedure can explain what we mean by pleadings? Peter, would you like to explain what that is? Put you on the spot.
Yeah, you have actually.
Sorry.
It is basically the procedure, your case.
Yes.
It goes before the court.
That's
yes,
a great way of describing it. It's the formal setting out in a documentary form of your case. So that's a good way of doing it. So they're the pleadings. So arbitrators can ask for that. And Tim gives some examples here of pleadings, the claim and the statement of claim, correct. All right, so when we talk about arbitration, there are two main things to consider from a historical perspective. The first is that in the Constitution, there was limited reference to arbitration, and there was early legislation that dealt with arbitration. But more recently, we look to the United Nations. So in terms of commercial arbitration, look to the model law on international commercial arbitration from 1985. And it's the UNCITRAL is the acronym, UNCITRAL, Model Law on International Commercial Arbitration. So when we talk about the model law, I'm really talking about that was created through the UN Commission on International Trade Law back in the mid-80s. So the model law was designed to assist states, and by that I mean countries, to reform and modernise their laws on arbitral procedures, and in particular to ensure that there was a commonality about processes so that arbitration at an international level could work well. So what's happened is that even though the UNCITRAL model laws were created that had an effect on international states, that has filtered through to domestic state level. So when we talk about the arbitral process, we're talking about a few different discrete but interlocked steps. The first is the arbitration agreement. The second is the composition and jurisdiction of the arbitral tribunal. And the third is the extent of court intervention through to the recognition and enforcement of the arbitral award. That's where the matter does go to court. So that's from the UN Commission on International Trade Law website. So have a look at that website and it gives you a historical background to a lot of the material that relates to arbitration in Australia as it's practiced now. So the focus of international arbitration relates to primarily transactions, but even consumer transactions. And you'd be surprised if you look at the fine print on legal documents as to the number of times that there's reference to an arbitration. So you'll often see an arbitration clause in a document. So look out for that from now on. So when we talk about arbitration in a commercial context, we might think of it in terms of large-scale commercial disputes involving companies, Australian and international, but it doesn't have to be that way. It can be much lower dollar value, but no less important and significant, for example, in consumer transactions. And arbitration can be of a binding nature or of a non-binding nature. So like mediation and conciliation, it's a little bit hard to pin arbitration down, but we're tempted to pin it down to some degree by reference to a definition. And you've probably come accustomed to the fact that when it comes to a definition, I will generally go back to the NADRAC definitions. So you'll recall NADRAC, which is a former body, but still influential. So NADRAC say that arbitration is a process in which the parties to a dispute present arguments and evidence to a dispute resolution practitioner, who is the arbitrator, who makes a decision, which is called an award. So the interesting thing about that is that arbitration involves parties presenting arguments and presenting evidence. So you can see that the very nature of arbitration is different to mediation in that it's directed towards the arbitrator, whereas in mediation and conciliation, I was saying that ADR practitioners go out of their way, as it were, to direct the attention of the parties to each other rather than to him or herself. So you'll see that that's a fundamental procedural shift between conciliation, mediation, and arbitration. But there are some key features of arbitration. It's not court, even though it looks a little bit like court. And the main difference there is it's private. It's a private regime as opposed to a public regime. Now you can imagine that there would be huge advantages in having your matter determined in a private setting. Who can think of some of the types of disputes that might be usefully dealt with in a private arbitration setting rather than an open court? I'm sure you can think of some. Any suggestions?
Intellectual property disputes.
Yes, yes. And because of the nature of the intellectual property, I guess, Jack, you don't want it to get out.
Yeah, where trade secrets are sort of on display, where you kind of want to keep it a secret.
Yes, absolutely. The very nature of the intellectual property is to keep it your property rather than be released. Tim says construction variations. Yes, construction variations may well lend itself to arbitration. Any other types of disputes? Really, there's a whole range of them. But anything where the parties can benefit from having a private structure rather than a public domain and reported decision is likely to be a good thing. Jack says sensitive medical disputes. Yes. Compensation claims might be another one, depending on the sensitive nature of the alleged acts. So arbitration can be voluntary, of course, but it can also be mandatory. Now, it can be mandatory in a couple of ways. The first is that it can be court referred, but the most likely is that the parties have committed by a contract to make arbitration mandatory in the event of a dispute. That's the most likely scenario. So having signed a contract to say, in the event of a dispute, the matter will be referred to arbitration, what do you think a court is likely to say if you bring an action in front of a court instead of initiating proceedings before an arbitrator? Any thoughts?
They might turf your way to go do arbitration.
Yes, they may well do that. They may well do that, and probably would. And we'll talk about some cases where the courts have construed arbitration clauses very broadly in favour of having the matter referred away from the courts towards arbitration. Now, of course, arbitrators are impartial. They make a decision that's based on the law in relation to the evidence presented to it. Usually the parties select the arbitrator, and the arbitrator is often an expert in the field of the dispute. It might be a barrister or a retired judge quite often. So when you're preparing your work for the examination, you might want to at least have a checklist of what are the advantages of arbitration, what are the advantages of litigation. In order to do that, you need to understand the difference between the two, and you'll need to be in a position to make an informed decision as to which is the better way to go for a particular client in a particular circumstance. So, arbitration versus litigation. The first thing is that they're both essentially adversarial. It's not like mediation, which is facilitative. It's not a negotiation where there's a lot of lateral thinking. Arbitration is essentially adversarial in nature. And of course, the third party makes a binding decision, usually binding. And it's a formal process, so the parties may agree that the rules of evidence apply. So if you go to an arbitration, it often looks like a court. People are giving evidence, and sometimes the rules of evidence are, by agreement, said to apply. So no hearsay, no leading questions, no opinion responses unless you're an expert, things of that nature. So it's certainly similar to a court proceeding, as in you've got lawyers often arguing a case for the parties, and the parties are giving evidence. Tim raises a good point and says, well, in a way, why would we be spending money? And I'm adding a bit to your question here, Tim, but why would we be spending money to engage in arbitration when we can go to the courts for free? Tim says, well, maybe we're wasting the court's time if we go to court. Can anyone think of any other reasons why you might want to go to arbitration instead of going to court in full litigation? Yes, Peter.
Speed.
Time. Yes. Yeah. Thank you, Peter. Yes, Michael. What did you say?
I just said speed. So same
Speed.
thing.
Yes. Same situation.
Can be
Speed.
opportunity cost, so it can be cheaper in the end.
Opportunity cost. Yes, can be cheaper. I agree with that. Nadine says it's determined by an expert in the field. Yes. So that's another important point. Any other reasons why you might go to arbitration rather than litigation?
You might, in arbitration, you sort of have a bit more control over the outcome, as opposed to going before a magistrate or a judge and who will make the decision from what they see.
Yes, I agree. So you've still got some greater degree of control. Yep. All right. So think about that, and as you're going through your reading, create lists as to why you would go to one rather than the other, but you need to understand what the difference is. So they're different in that usually, unless it's court-ordered arbitration, there must be the consent of the parties. It's different in that one is private, the other's public. It's different in that usually the arbitrator is selected by the parties as opposed to a judge who is tenured and assigned to the matter. And it's different also because the result is binding on the parties to the case. In other words, there's no precedent value in a matter. So if, for example, a defendant in relation to a defendant organisation in relation to sexual misconduct claims effectively settles the matter through arbitration, which is private, then it's not something that should be used as a precedent for later cases. Each case will stand on its own 2 feet. All right, so when you're doing your homework, you need to consider another thing, and that is the difference between arbitration and other forms of ADR. So, for example, again, looking at page 3 and the diagram, you'll see reference there to number 8 or number 9, and I've numbered these. So number 1 is top right-hand corner is negotiation, number 14 is arbitration, bottom left-hand corner. Number 9 is expert appraisal. So for the purposes of your exam, I would expect that you would be able to answer a question as to explaining the differences and the similarities between arbitration and expert appraisal. And the reason I raise that is that we've talked about arbitration as being a result given by a person who is essentially an expert. So why is arbitration then different to expert appraisal or expert determination? So we need to know the answers of this for our assessment, for our final assessment. So between arbitration and expert appraisal is a process in which a dispute resolution practitioner is chosen based on their knowledge in the field, and that person investigates the dispute. That's not going to happen in arbitration, is it? Because in arbitration, I've mentioned that it's essentially adversarial in nature. It can be to a degree inquisitorial, but essentially it's adversarial. And the appraiser then provides advice on the facts and the possible desirable outcomes and the way in which they might be achieved. So expert appraisal is much more like engaging an expert for advice, but advice with a lot more teeth, as opposed to arbitration, which is much more like being in a courtroom. Now, I mentioned that there is a legislative basis for arbitration that goes back to the Constitution. Can anyone tell me what constitutional power might exist in favour of the Commonwealth that would enable it to undertake or make legislation in relation to arbitration? Any thoughts?
Section
Peter?
51 XXXB.
Spot on. Very good. Thank you. Which is in relation to,
Wasn't sure of the number of X's there, but
you got it right. I was counting them as you were saying it. 35 for those younger ones who don't know the Roman numerals. We do have some young people in our class. I'm not sure if they teach Roman numerals at school anymore. So well done, Peter, says Tim. So employer-employee relationship disputes covered by 5135. Now the states introduced the Uniform Commercial Arbitration Act. So arbitration is governed by broader legislation. How is that? How do we have legislation created through states as opposed to the Commonwealth? Can anyone tell me?
it's
Yes, Peter?
mirror legislation that's been passed by the states
Yes?
to cover, so that everybody's on the same page, similar to the Corporations Act.
Very good. Yes. So with the Corporations Act, we had essentially an agreement between the states as to how this would be enacted, and it was done through a Commonwealth level. States introduced the Uniform Commercial Arbitration Acts so that we have some degree of uniformity. And that all goes back to Unitrol. So this uniform legislation in Queensland is evidenced by the passing of the Commercial Arbitration Act 2013. So that's your go-to legislation for arbitration legislation in Queensland, and it's part of the uniform legislation, so that there is not the same but very similar pieces of legislation around other states of Australia. All of this goes back to the Standing Committee of Attorneys General, who proposed in 2010 for a nationally adopted framework for domestic commercial arbitration in Australia, and all of that was based on the Unitrol model law that I mentioned from the mid-80s. So when you read about the Commercial Arbitration Act 2013 Queensland, you're really looking at the Queensland version of the uniform legislation adopted by states and territories. So all good? You with me so far? Okay. And it all goes back, as I mentioned, to the, it's actually the 2006 United Nations Commission on International Trade Law, the Unitrol model law. So the initial discussions were back in the 80s, but the actual model law is 2006. So if you have your legislation available now, I'd encourage you to look at it as we speak. And you'll see section 1AC of the Commercial Arbitration Act 2013 Queensland, which I'll just call the Commercial Arbitration Act or the Act. Section 1AC deals with the paramount object. And the idea is for the Act to legislate for the fair and final resolution of commercial disputes by impartial arbitral tribunals without unnecessary delay or expense. So if you're looking for some commentary about the advantages of arbitration, have a look at the objects of the Act. I think you'd certainly need to look at the explanatory memorandum, the second reading speech, and then the objects of the Act, so that when you're saying these are the advantages, you can say, well, that's consistent with what was intended by Parliament in introducing the legislation. It's meant to be fair, it's meant to be final, it's meant to be impartial, it's meant to be undertaken without unnecessary delay, and it's meant to be without unnecessary expense. So from the definition, there's 5 advantages of it. So I mentioned that the parties can approach an arbitrator. If approached, a potential arbitrator must disclose any circumstances likely to give rise to justifiable doubts as to impartiality or independence. Same applies to a mediation. But in this instance, refer to Section 12 of the Act, which provides for a legislative obligation to be imposed upon the arbitrator before accepting an arbitration commission. Now, it's called the Commercial Arbitration Act, but it's actually wider than you might think. So in terms of the scope of application of the Act, have a look at Section 1, subsection 1, and you'll see that it says the Act applies to domestic commercial arbitrations. And the determination as to whether something is domestic or not is found within the same section. And you'll see that the Act talks about a connection to Australia rather than Queensland. Normally, when you're looking at state-based legislation, it refers to the state. It refers to Queensland. But given the nature of this as uniform legislation, we're really interested in having a connection with something to do with Australia rather than just Queensland. So subsection 1(3) says an arbitration is domestic if the parties have their place of business in Australia and the parties have agreed that any dispute between them is to be settled by arbitration, and it's not an arbitration to which the model law, that is the as given effect by the International Arbitration Act 1974 Commonwealth, applies. Now, this is the Commercial Arbitration Act, but the word commercial is not defined. In your text, Spencer raises an important issue, and it's this. Spencer says, interestingly, the name of the acts, referring to the Uniform Commercial Arbitration Acts, is somewhat of a misnomer, in that there's no restriction to invoking the acts based on the subject matter of the dispute. In other words, the acts can be invoked whether the dispute is commercial in nature or not, and according to Spencer, the word commercial could be removed from the title and not have any effect at all on the operation of the Act. We'll just call it the Arbitration Act. I'm not convinced that Mr. Spencer's statement is entirely correct when one considers the footnote to Section 1, subsection 1 of the Act. To me, that gives some indication as to the meaning of commercial because it refers to the model law note, and it says the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. And it goes on to give some examples. So there is a preliminary issue as to when the Act will apply in relation to certain types of disputes, but not others. So, for example, a family law dispute would clearly not be covered by the Commercial Arbitration Act. It's covered by different legislation, but not this Act. So, for the purpose of your assessment, if you were presented with a problem where the parties were keen to proceed to arbitration, you'll need to overcome the initial question as, does this qualify as a dispute covered by the Commercial Arbitration Act? And if so, why? Or, as always, look beyond the mere words in the legislation, consider case law, but also consider the objects of the legislation, second reading speech, and the explanatory note as it is in Queensland. So think about your statutory interpretation principles there. Once we've decided that this dispute is one that can be dealt with under this Act, then of course we need to practically, from a practical perspective, we need to invoke it. So you'll need to know how the Act is invoked. And the answer is that it's invoked when the parties enter into an arbitration agreement, or where legislation empowers a court to do so the matter is referred by a court to arbitration. You'll need to consider the form of the arbitration agreement. Have a look at Section 7 of the Act. It must be in writing, and it must be in the form of an arbitration clause in a contract or in a separate agreement. So what does that tell you? When you look at Section 7, it essentially tells you that the arbitration agreement can be created even before there's a dispute. So when the parties engage in a contract, they might anticipate the possibility of dispute and come to an agreement at that early stage that if there is a dispute, it goes to arbitration. Or it may be that after the dispute has arisen, the parties enter into a standalone, as it were, arbitration agreement. When you're considering whether to proceed to arbitration or not, be mindful of the fact that it's very common in a commercial context in particular for the parties to agree to arbitrate rather than to litigate. And if they do, then that takes priority. If, despite the arbitration clause, a party does take court action, then the general rule is this, we've talked about it earlier tonight, the court must refer the parties to arbitration, and there are only some limited exceptions to that principle. So if there's an arbitration agreement, the matter will go to arbitration. You're probably wasting your client's money by going to court, but when would the court refuse to allow the matter to proceed to arbitration? Any thoughts? When would the court say, yeah, all right, we will take this one, even though there's an arbitration clause? No thoughts?
Where maybe we're forcing them to go to arbitration would create undue delay. Like it would increase the delay. That was a guess.
Potentially, but not exactly what I'm thinking of. But it's a good guess. Anyone else? Because this is the sort of thing that we put in an exam, don't we? I'm giving a few hints tonight. All right. Have a look at Section 8 of the Act. And it says that the court must refer the parties to arbitration unless it finds the agreement is null and void, inoperative, or incapable of being performed. So the exceptions to allow for the matter to proceed to litigation are quite limited. Now, a recent case from the High Court dealing with this point is the case of Reinhardt, as in Gina, and another, against Hancock Prospecting. And the citation is 2019 HCA 13. So we don't have the CLR citation just yet, at least I haven't seen it. So Reinhardt against Hancock Prospecting, 2019 HCA 13. In that case, there was a dispute resolution clause calling for arbitration in the event of a dispute. But it said, in the event of a dispute under this deed. The complication in this case was that there were allegations alleging breach of equitable and contractual duties against other parties who weren't directly parties under this deed. The applicants asserted that they were not bound by the deeds, partly because they were not parties, but also because their assent to proceed to arbitration was procured by misconduct of the other parties to the deed. So the whole case related to validity claims and whether validity claims were made subject to arbitral clause. So again, the court referred to Section 8. This time it was the New South Wales Act, but essentially the same as Queensland. and it said that the matter needs to go to arbitration where there's an agreement. So what you can take from that case is this. When you're looking at a contract, as was the case in the Reinhardt decision, look at the first starting point would be to look at the language used by the parties and the surrounding circumstances and the purposes and objects of the contract. It's almost like statutory interpretation. So that's the court say, let's take this expansive view of the document before we drill it down to the actual words. So that's what we do when we're construing a contract. That's what we do when we're looking at an arbitration contract. The principle is the same. But what we can take from the High Court is that when construing arbitration clauses, courts will do so widely. They will not take a narrow approach to this. So unless there are clear words that limit the operation of the arbitration clause, then the courts will not limit their operation. Under this deed, the words that are actually used in that case should be given a liberal as opposed to a narrow interpretation. The context did not otherwise require, so therefore everyone was caught up in the arbitration clause. Also recently in Queensland, we had bulk build Pty Ltd. That's BULK build, one word, Pty Ltd against Fortuna Well Pty Ltd. And the citation for this case is 2019 QSC 173. This was again a case as to whether the matter should be dealt with in arbitration or litigation. The background of this case was there was a construction contract and a dispute arose between the contractor and the principal. It was to do with unpaid work. Now the contractor alleged that the superintendents, who were not parties to the contract but were responsible for administering the contract, were negligent in their duties. And the matter came before Her Honour Justice Boskill, formerly Judge Boskill, now Justice Boskill, who considered an application for referral of proceedings to arbitration under Section 8 of the Act. And Her Honour held that Section 8 does not confer a discretion on the court to refuse to refer proceedings when the conditions for referral are met. So the courts will work on this basis. They'll only find that arbitration agreements are incapable of being performed, to use the wording in Section 8, in very limited circumstances. In fact, the effect of the decision was to include the superintendents in the arbitration even though they were not parties to the arbitration agreement. That's how broadly the court construed that section. The rationale behind that was that if the matter was to proceed to litigation, the superintendents were likely to argue through or under the principal contractor, so that there was an intertwining of facts and law. So the practical effect of the decision was that there would not be parallel litigation and arbitration in relation to the same issues. All right, so the takeaway from Section 8 is courts will look at this very broadly and will uphold arbitration agreements wherever possible, even if it might appear that to do so is slightly, with respect, strained. Oh, you've been very patient tonight. You've been very good. We can wrap it up very soon. But before I do we have any questions? And I do thank you very much for your contributions. All right, all good? Okay, thank you very much. We'll see you this time next week. If you have any questions, please ask through Q&A. Please aim to complete your assessment during this next week or 10 days. All good? Okay. We'll see you next week. Bye then.
Thanks, John.
Bye.